In the criminal justice system, evidentiary-based miscues are considered especially heinous. In Professor Andrews' class, the dedicated lawyers who prevent these vicious miscues are members of an elite squad known as the Federal Rules of Evidence Unit. These are their stories.
Winky Winky song bag.
They won't let me out, no. They won't let me out. Locked up. They won't let me out. They won't let me out. Locked up. They won't let me out, no. They won't.
You're about to enter the courtroom of Judge Judy Scheinman. The people are real, the cases are real, the rulings are final. This is Judge Judy.
Let the record show that Mr. Winky is present for the courtroom with his counsel. Would the counsel please state their appearances for the record?
Good morning, Your Honor. I would kill you, Bird, for Mr. Teletubby, who's now present.
Good morning, Your Honor. Go and get you for the people.
Y'all get you?
No, Judge. It's go and get you. It's French.
I see. Mr. Winky, you are being charged with sexual assault of little Peter. How do you plead?
Not guilty, Your Honor.
All right, prosecution may begin with your opening statement.
In the name and by the authority of the United States of America, Tinky Winky, hereto styled the defendant, heretofore on or about November 10th, 2011, did and then there unlawfully, intentionally, and knowingly have inappropriate contact with little Peter. The contact was sexual in nature. Tinky Winky is a sexual predator, and the evidence in this case will show you that people in this world who think they know him best know him least.
Counsel for the defense, Tinky Winky and his family. This is a case of misidentification. My client is a good man, Teletubby thing, and Mr. Winky is a peaceful man who would never abuse a child. And furthermore, I don't even know if he has sexual organs.
Okay. After a short break, the prosecution may begin with their case in chief.
It's my evidence. I need it now.
Perfect.
How are you doing today, buddy?
I have this pending case and all this great evidence, but the judge won't admit it.
Boy, that is just rotten.
It's my evidence, and I need it admitted now.
It's his evidence and he needs it now.
It's my evidence and I need it now!
Are you in the middle of the trial and the judge won't let you admit any of your evidence? Have you tried using Rule 401 to make a fact of consequence to the trial more probable? Have you tried using 402 that admits all relevant evidence? And in additionally, have you made a timely objection? If you answered yes to all of these questions, then the judge must admit your evidence now. I'll get your evidence in today. Call 1877, admit now.
Yeah! Woo! Woo!
I would like to call Mr. Poe to the stand. Mr. Poe does not speak English and needs an interpreter. His brother-in-law, Jolly, will be interpreting for him.
Objection, Your Honor. Bias?
His brother-in-law is a professional translator who gave an oath to make a true translation under Rule 604.
Overruled.
Mr. Poe, isn't it true on the night question you heard little Peter Peter cry and say, "No, Tinky, don't touch me there."
Objection, Your Honor. Hearsay.
It's a present sentence impression, Rule 803, Your Honor. It also goes to an excited mental state and an excited utterance.
Overruled. Come on, don't bother me with these incompetent objections. Please continue.
Again, Mr. Poe, isn't it true on the night in question you heard little Peter cry and say, "No, Tinky Winky, don't touch me there"?
He said he heard crying, but he didn't know who the voices were from the conversation.
How can you not distinguish the voices? These are people you've worked with on a daily basis for many years. Are you honestly telling me that there's no way you can recognize the voices?
He's not sure.
You've got to be kidding me. How can you not know these voices?
Objection under 611, Your Honor. Harassing the witness.
Sustained. Don't try and get around the rules here, Mr. Getchu. What do you think about putts? You better stay in line, counselor.
Okay, but you should answer the question.
He's just not sure.
Your witness.
Why couldn't you recognize the voices?
He's saying that all of us Teletubbies sound the same.
So, are you saying that the sounds were indistinguishable or even identical?
He said, identical!
The defense rests, Your Honor.
Your next witness, counselor.
Guys, come on, we gotta focus here. Test is tomorrow. Rule 801D1, this is a really important rule. It clearly states, and this is, she kept stressing this, you guys gotta, what does it say? What does it say? Oh shit, I don't even know. What does it say? Do you guys know? Do you guys know what Rule 801D1 is?
That's a clown question, bro.
Clown question?
Abby, why don't you pop a mental?
That's a great idea!
What?
Here you go, guys!
It doesn't matter what comes, fresh goes better in life. With mental fresh and full life. Nothing matters to you, day in fresh, day in full. With mental fresh and full life. Fresh goes better with mental fresh. Fresh goes better with mental fresh and full.
That a statement that meets the following conditions is not hearsay. 1. A declarant's statements, a declarant's witness prior statement, the declarant testifies and is subject to cross-examination about a prior statement and the statement, Munil.
A. Is inconsistent with the declarant's testimony and was given under penalty of perjury at a trial, hearing, or other proceedings, or in a deposition.
Yes!
Dude, give it to me.
It's consistent with the declarant's testimony and is offered to rebut and express an implied charge and declarant recently fabricated or acted in a recent improper influence or motive and so testifying, or
Boom! Lindsay!
Identifies a person as someone the declarant perceived earlier. Woo!
Your Honor, defense calls Lala to the stand.
How did you get Lala? She's all the way in Teletubbies.
We flew her in for 1 day, and 1 day only. Sucks for you guys.
Objection, Your Honor. We would ask that the witness not be excused prior to cross-examination.
Sustained defense, you want a fine line here. Don't try and pull one over in my courtroom. The prosecution will have an opportunity for direct examination today.
Now, Lala, what can you tell me about Tinky Winky?
Tinky Winky's a great person. He wouldn't hurt anybody. He has a reputation reputation of being very professional and courteous to both children and adults. He's even a board member of Parents Against Child Abuse organization. He also helped a little boy who was being sexually abused by his uncle.
Objection, improper character. Narrative and too specific character reference.
Defense can open the door to a pertinent character trait. Here is a propensity to commit assaults on a child are an issue.
Yes, but whether or not he is a great character is irrelevant as to whether or not he's courteous anyway. The other examples are specific instances, and the defense can only use reputation and opinion on direct.
Sustained as to all parts of the objection, except for the statement, he would never hurt anyone. Carry on.
No further questions, Your Honor. Your witness.
Lala, did the defense pay you for your testimony?
Objection. We are allowed to pay reasonable travel expenses and out-of-pocket costs. Also leading.
We're treating the witness as hostile.
Fine. Overruled. You must answer the question, Lala.
Yes, the defense paid for my flight and my hotel.
Lala, did they pay you to testify? Keep in mind you were under oath and under penalty of perjury.
Yes, they paid me $10,000 to testify.
Prosecution, Your Honor, sorry. Your Honor, we would like to strike Lala's testimony from the record.
Sustained. Defense, you better not try to forget in my courtroom. One more slip and I'm holding you in contempt. I will not exclude the witness, but no $10,000 payment will be made.
So in my case, they're going to talk about an important issue on direct, and then I'm going to talk about something totally different on cross.
Silly rabbit, you can't go outside the scope on cross. Kid tested, magistrate approved.
Your Honor, defense calls Tinky Winky to the stand. Hello, Mr. Winky. Just have one question. Now, where were you on the night of the alleged incident? Mr. Winky, could you look at me, please? Once again, where were you on the night of the alleged incident? Your Honor, permission to treat the witness as hostile.
You may proceed.
Think I'm hostile now? Wait till you see me at home.
For a third time, Mr. Winky, where were you on the night of the alleged incident?
I was at my residence, the Tubbitronic Superdome. I was watching Mr. Rogers.
And could you tell me what that episode of Mr. Rogers was about?
I can't remember, but he was wearing a red sweater. I know that.
Now, Mr. Winky, did you assault little Peter?
No, I would never harm that child. I love him.
Your Honor, defense rests. Your witness.
Mr. Winky, isn't it true that you raped little Peter?
Objection, Your Honor. Leading the witness.
Seriously now, where did you go to law school? Rowan? You can lead on cross. Sustained.
My apologies, Judge Judy. Again, Mr. Winky, did you... Mr. Winky, had you watched the show Mr. Rogers before?
Yes, it is one of my favorite shows. Besides my own.
So then did you know that Mr. Rogers wears a red sweater in the majority of his episodes?
Oh, I never thought about that before. I suppose he does.
Mr. Winky, isn't it true that in two previous incidents, in 2007 and 2008, when you were in the Tubbitronic Superdome, you were engaging in sexual misconduct with a minor?
Objection, Your Honor. Improper character. There's no convictions.
It's appropriate to, in sexual assault cases and child assault cases to introduce prior incidents even if there is no conviction.
Prosecution needs 3 or more instances to establish a habit, Your Honor.
Bitch, please. 414A still says that in a criminal case in which a defendant is accused of child molestation, the court may admit evidence that the defendant committed other instances of child molestations. The evidence may be on any matter to which is relevant, and in this case, the probative value outweighs the prejudicial value under 403.
Overruled. Continue.
Thank you, Your Honor. Again, Mr. Wenke, isn't it true that in two prior incidents, in 2007 and 2008, you were in the Tubbytronic Superdome with a child and you were engaging in sexual misconduct with a minor?
Yes, I was charged for those crimes, but I still maintain my innocence. I didn't do them. The witnesses didn't testify, and the charges were dropped.
The prosecution rests.
Redirect, Your Honor.
Proceed.
Tinky Winky, are you saying that you did not commit these crimes or any other crime of child molestation?
Let me be clear. I have never committed any crimes toward children. It was a case of mistaken identity.
No. Now, do you know who committed these crimes?
Yes, but I cannot reveal who they are. I'll plead the fifth.
No more questions, Your Honor. The defense calls Ipsy Dipsy to the stand. Ipsy Dipsy's twin brother, Dipsy, recently died of syphilis, but we're here to obtain a dying declaration before his passing. The defense would like to call Ipsy to testify.
Objection. This is a criminal case and this violates Crawford.
Dipsy qualifies as being unavailable under Rule 804A4, and dying declarations are historical exceptions to Crawford's right of confrontation.
Overruled. This is getting interesting. It's turning to an episode of Jerry Springer. We'll continue after this short break.
Jerry.
Have you been injured by a softball to the head by the Chintan?
Oh! I can't remember. Now I remember.
The use of Rule 612 allows you to introduce evidence and refresh the recollection of a witness. Here at Binder & Binder, we have binders full of women who have been injured by the Chintan. We'll deal with the Chintan. You have enough to worry about. Nobody takes advantage of our clients. Nobody. Just call 1-800-66-BINDER.
Jerry.
All right. Order in the courtroom. Defense, you may play Dipsy's testimony.
Just wanted a jury. Thank you, Your Honor.
Yeah, I did it. Little boys of my ish. It was fun. They liked it, although, I must say, Little Peter was my favorite. You know, I'd like to throw some thanks out to my homeboy, Tinky Winky. Dude, you're the man, bro. Thanks for taking the fall. You're the best bro ever. I'd do it again, too.
Your Honor, the defense would like to file a motion to dismiss.
The prosecution drops all charges.
Wow. You've got to be kidding me. The charges are dropped. Next case.
So seductive. I take you to the candy shop. I let you lick the lollipop. Go ahead, girl, don't you stop. Keep going till you hit the You gon' back that thing up or should I push up on it? Temperature rising, okay, let's go to the next level. Dance floor jam-packed, hot as a tea kettle. I break it down for you now, baby, it's simple. If you be an info, I'll be an info. In the hotel or in the back of the rental, on the beach or in the park, it's whatever you into. Got the magic stick, I'm the love doctor. How your fans teasing you about how I sprung, I got you. Wanna show me you can work it, baby? No problem, get on top, then get to bounce around like a low rider. I'm a seasoned vet when it comes to this shit. After you work up a sweat, you can play with the stick. I'm trying to explain, baby, the best way I can. I melt in your mouth, girl, not in your hand. I take you to the candy shop. I let you lick the lollipop.